and the integrity of the judges sitting on the court is beyond reproach. And no one has ever suggested that anybody on the Caribbean Court of Justice has shown signs of a lack of will to maintain his independence and integrity. So that while I understand what you're saying, but I think it is based on a fundamental misunderstanding of what it takes to make a person a judge. You can't, not any and everybody can be a judge. You see, what happens is that you have the profession observing you over a period of time. The profession will know what your weaknesses are. The profession will know whether you are the type of person who should be a judge. So that, you know, in the Caribbean Court of Justice, you cannot be a judge unless you have been a Court of Appeal judge. You arrive at being a Court of Appeal judge after many, many years, and there's a whole process of attrition whereby you start as a High Court judge, and then only the best go up to the Court of Appeal, and then you get to another stage where only the best out of the Court of Appeal can go to the Caribbean Court of Justice. And that is a regional competition. Now, in terms of having people from abroad, what the rationale behind that was that in the initial stages, when people are still not used to the idea of their own court, they want to be sure that there is an input from people who have a background which is not known among the population. In other words, that they are not people who know the society in the sense that they know people in the society. These are independent people. They don't know who John Thomas is or who even the Prime Minister is. They've never had any social interaction with them, and they really don't know them. So there's no question of saying that Mr. X, who is a Dutchman, was influenced by the politician, or Mr. Y, who is an Englishman, was influenced. He doesn't know these people, and he doesn't care about them. So that is why that was introduced. On the other hand, it was also introduced because you could get the kind of expertise from other countries. For example, in our case, Professor Hayton, who is a world-renowned leader in trust law, we have him sitting in our court. So that when we have matters of that kind, you know, our judgments will be second to none. And already we are making an impact in the sense that the judgment that was referred to by the learned Attorney General, the Da Costa and Hall matter, that has itself been cited by the Privy Council in one of their cases. So that it is not as if it's not as if our competence is doubted by even the Privy Council. Not even doubted by the Privy Council. They've actually relied on one of our decisions. And what we propose to do is to open the range of the pool of cases, the pool of precedents which we can have recourse to not only the rest of the Commonwealth, but the entire world, wherever there's a judicial system that is reputable. We want to have recourse to that, and that would include the United Kingdom. So there's nothing lost by coming to the Privy Council, because we will look at the UK jurisprudence, and we will look at the Australian, and the Canadian, and the New Zealand precedents. So that, in fact, what you have is a much more liberal and a much more researched type of judgment, because we are not confined to UK decisions, and we are concerned with what is happening in the world on that topic, and that includes Australia, New Zealand, Canada, South Africa. That is how our judgments are written. We are not concerned only with what is happening in the UK.
Thank you, Justice Nelson.
Yeah, I'd just like to support like to support Mr. Justice Nelson in relation to the question of the independence and integrity of the judges who form part of the Caribbean Court of Justice. The setup of the court is one in which is seen as a model internationally for independent courts. It is made up in terms of the selection of the judges. There's a regional judicial and legal services commission made up not by any politician, any government. You have representatives from the universities in the region. You have representatives from trade unions. You have representatives from the public service commissions in the union, in the region. There are no politicians who determine which judge is selected. And as equally important is the issue of a regional trust fund. Every government in this region has had contributed to a trust fund that finances the court. $100 million have already been paid. They do not need to go to any government, any politician for $1 to pay any salary. There is a trust fund that is managed by independent people representing the Caribbean Development Bank and other institutions that manage this trust fund, actuaries who invest it, so that into the future, the court does not have to rely on any government, any prime minister, or any politician for their salaries, for any monies to operate. It is an independent court, and it is used as a model to the rest of the world.
Thank you, Minister Byron, for that. We have 3 more questions, and then we go to lunch. Lunch is going to be served here, and immediately following the lunch, and we have to reduce the time for lunch. We are asking everyone's cooperation. We are asking that we take a half an hour lunch, because we need to come back to complete our agenda.
Thank you very much. Notwithstanding all that was said regarding the last question, which is the political influence, I think that there is a crisis of trust with regard to the CCJ. And the question is, why is there this crisis of trust? I want to suggest, gentlemen, that whenever there are issues regarding citizens, the courts, they do fairly well. But whenever there is an issue between a citizen and its government, that is when we seem to have a problem. And I'm glad that you raised that point, Mr. Attorney General, of the observer case. Because were it not for the Privy Council, there would be no observer newspaper or observer radio. You see, and that is the problem. And from time to time, we have had cases where individuals come up against their government, and the courts have ruled in such a manner that we have had to go to the Privy Council to get justice. And once that is in play, then the population is going to be very skeptical about the Privy Council, about the CCJ. And that, I think, is the issue. And the question, therefore, is, how do you restore trust within the population with regard to the CCJ, particularly when it comes to government versus their citizens?
We will take the other two questions at one time.
Okay, so previously it was stated that if you eliminate crime, then it will help develop the countries of the Caribbean more. But there haven't been any strategies put forward that I've heard of in regards to eliminating the crime. When you go to different forums and listen to the news, you'd always hear that they want to eliminate crime. But you're never hearing the strategies or the ideas that they're pitching forward to eliminate the crimes. So my question is, what strategies or ideas are you pitching forward to eliminating the crime to help develop the countries?
Thank you. Last question.
Good afternoon. My name is Curtis Cornelius, a second-year law student at the KFA Law Faculty. And my question is about enforcement of the court's judgment by the other Caribbean governments. So now, for example, in the Shanique Mary case, it took Barbados over 8 months to pay her compensation. And there were even reports that the monies came short. So what mechanisms are there in place for there to be enforcement of the judgments by the courts? Thank you.
Thank you. Thank you ever so much.
If I may be permitted, to my young friend from Christ King High School, the matter of elimination of crime is not really a matter for the court. It's a matter for the state. And each individual country will have to address its mind as to how best it addresses its crime issues. St. Kitts will look at it, Antigua, St. Vincent, and so on. But it's only where judgments have been given or somebody feels he's been wronged that they go to the court for redress. But the matter of crime in the individual states is a matter for the government in that state. With respect to you, my friend, I believe my friend Mr. Byron, Honorable Byron, and the senior judge of the court has stated clearly, the judges are insulated. There's a trust fund established. The methods of election, and he's quite right, is unique and is regarded by many countries of the world as a model to select persons to perform duties such as judges in this particular court. Now, the appeal in the observer matter was from the Eastern Caribbean Appeals Court to the British Council. Now that we've got our own CCJ, and there was an appeal in a similar matter, that appeal will go to the CCJ. And as I indicated, I am totally supportive of my friend Mr. Byron and Senior Judge Nelson, that not only ethically, educationally, but they are insulated, they are independent, they shall be not by the governments who make a determination. So there's no impact, no influence by any politician on the judges as this is. And remember, Justice Nelson is right. These are men and women of impeccable character. Don't you understand that in England, that some of the law lords are familiar with the politicians there as well? In England, don't you think that some of the law lords know these politicians from the Tories party or from the Labour Party or from the Green Party? It happens. But the fact is, their independence and their integrity is such that when it comes to the application of the law, the development of their jurisprudence, that has no impact whatsoever with respect to their judgments. And I ask my friend to deal with the question of enforceability, the enforcement of judgments.
The question of enforcement is a troubling one, but to date, we have not seen any case in which this has not happened. In terms of the Myrie case, the Barbados government did pay the judgment. It's not a question that they did not pay it, and there was any doubt at all. And this was done relatively expeditiously. And I would say that it is a point to where our governments in the region have lived up to their responsibilities. And And I think that we should have trust in that. I just want to make one other point on the question of trust in the courts. And the question is that the Privy Council is a final court. Final courts tend, I would say, to understand their function and role. And I think maybe Justice Nelson may be even better to speak to that than I am. But with a final court, you understand your function. And it's, if we look at issues in the United States, in Canada, and other common law jurisdictions, the final court has a certain character to it, that not to suggest in any way that law courts do not, but I have no doubt at all that faced with the same facts and the same situation, that a final court in the Caribbean would arrive at the same decisions as the final court in London.
After that, I think the learned Attorney General St. Kitts may have had a similar an experience which convinced him and that is so. The fact is that if the St. Kitts case had come to the CCJ, the decision would have been the same. If the Observer case had come to the CCJ, I can assure you the decision would have been the same. But why do you think that if those cases came to us, they'll be different? Sitting on the final court, I don't see them. There could have been any other decision. But you see, again, it's a question of, do you really believe in your own?
Thank you. Thank you. The Honorable Justice Ralston Nelson, Senior Judge of the CCJ, the Honorable Stedroy Cutie Benjamin, our Attorney General, and Minister, the Honorable Vincent Byron, Attorney General of St. Kitts and Nevis. I thank you, gentlemen.